Welcome back to This is VANCOLOUR. It's a fear of many renters in British Columbia, particularly in Vancouver, the fear of being evicted. Legally speaking, what grounds does a landlord have to be able to evict a renter? And what are your rights as a renter? Here to explain is my counterpart on the Soapbox Social panel, which you can find on CBC Radio's On the Coast with Gloria Makarenko, representing Acumen Law. She is Kyla Lee, and this is Kyla's Court. So Kyla, let's say a landlord wants to kick a renter out of the place of dwelling. What legal grounds must they meet to be able to do that?
There are a bunch of different legal grounds they could have. It could be chronic late rent or non-payment of rent, breaching a fundamental term of the tenancy agreement, or things like moving in an immediate family member, meaning a parent, a spouse, or a child. So
the landlord wants to move into the unit, basically, or the owner, I should say.
The owner or their immediate family.
What about their friend?
Can't move in your friend and evict a tenant to do that. That would be illegal.
In terms of breaching sort of the tenant agreement, what if I throw a rager and my landlord says, hey, you weren't allowed to throw parties, I got to kick you out?
If it was in your tenancy agreement that you couldn't have, a rager party because of some sort of neighborhood bylaw restriction or disturbing other tenants, then potentially. Although generally it's got to be a fundamental term of the lease, something that strikes at the core of the lease and not just having a party.
Okay, so I may have like some grace with certain things.
You get a little leeway. If you're putting thumbtacks in the wall, you're probably not going to be evicted lawfully for that.
Okay, and so that covers it in terms of reasons why you can be evicted.
There can also be rent evictions if the property is being torn down or in circumstances where renovation is being done that requires the person to be removed from the property.
But what if it's just a day that someone has to be removed?
Then that would not justify an eviction. It would need to be an extensive renovation that could only be completed by evicting the tenant. Okay,
but there's no set time period.
There's no set time period because every renovation is different. But if you're replacing carpet or painting the walls, that's not going to be something that's going to justify taking someone out.
Which level of government actually sets these rules?
This is done by the provincial government.
Okay. Now, let's say you are a renter and you're given an eviction notice. Let's say your landlord says, oh, I want to move into the place, or they have another reason. What is your recourse to make sure that that reason actually is valid and they're not just making it up?
You can apply for dispute resolution with the residential tenancy branch. Evictions are very strictly controlled. There have to be proper documentation. There has to be notice filed by the landlord with the residential tenancy branch. And then you have the opportunity to dispute any eviction and a hearing would be held.
Okay. Let's say that process is happening. Can your landlord lock you out in the meantime, saying, no, I need to move in or I need to do these renovations?
No, they can't actually physically get you out of the property until the dispute has been determined.
Okay. Now, when we think about bad faith evictions, what are the most common bad faith evictions that we see that maybe renters should be aware of?
I think the big two are moving in a family member that isn't actually a family member because they just want to get somebody who's going to pay a higher rent, or they're moving in a cousin or somebody who wouldn't qualify as family. And then the rent eviction, where it is just cosmetic repairs to the property to try and get more money for rent rather than a substantial gutting of the place that would require somebody to not be there for months and months.
Now, let's say you are a renter and you do get duped. The landlord does one of those scenarios that you just mentioned. Can you go back for recourse? How does that work?
You can go back to the residential tenancy branch for recourse, and the landlord can be ordered to pay monetary penalties to you as a result of a bad faith eviction. So it can be very costly to a landlord to do it in bad faith.
For the renter, is part of this just the time and effort that it takes to be able to go through this process? Is that one of the big hurdles?
It is a big hurdle. I've been a renter myself for many years, and I've gone through this process, and I've had landlords chase me down the street screaming at me, no one's ever taken it this far before, but...
Wow. Well, Kyla, as always, a pleasure to have you on the show. Thanks so much for your insights and for your legal advice.
Thank you for having me.
Folks, thank you so much for watching, and thank you, of course, to Ron Butler, Steve Soretsky, and cool Kyla Lee for tonight's show. She is so cool. If you have any ideas for Kyla's Court, please shoot me an email, mo@thisisvancolour.com, or just, say hello, say hi. Also, throw your phone in the ocean and go live your most beautiful life. You don't need to follow me on all the socials @VANCOLOUR. We will be back next week, but until then, be colorful. Peace.